There's a very interesting case there reported in the Irish Times. The reporting is by Fiachra Gallagher in the Irish Times. It's a Supreme Court decision in a case involving a man, Patrick Dillon, who was seeking damages from Irish Life over sharing letters containing his personal and financial data. This man, Mr. Dillon, was claiming that he had suffered distress and so on as a consequence of the sharing of the letters. And in the sharing of suffering distress, he sought to be compensated. He brought a claim against Irish Life over the distress that he suffered. However, the normal situation up to now in relation to any psychiatric or psychological injury that you might have suffered would involve firstly bringing an application to the Inuries Board, and then the Inuries Board giving you a letter of authorisation permitting you to bring legal proceedings through the courts on the basis of a psychiatric or psychological injury that you've suffered. However, if you came to a solicitor, you would have been advised up to a few days ago certainly that you need to be able to show, in order to be successful with a psychological or psychiatric claim, you need to be able to prove that you've suffered a recognised injury, a recognised psychiatric or psychological injury, recognised by who? By professional psychiatrists or psychologists. So it wouldn't be just enough that you've suffered anxiety or stress or upset, etc., etc. That wouldn't be enough. You must have suffered a recognised psychiatric injury. This decision, however, from the Supreme Court is a bit of a game changer insofar as it has decided that this man could bring this case, and the Circuit Court and the High Court were incorrect in refusing him or in deciding against him. He could bring a claim for damages, for distress, even though it wouldn't be recognised as a personal injury as defined in the personal injuries legislation. Let's take a look at the decision. The man claimed that he suffered distress, upset and anxiety arising from the financial service company's disclosure of his personal data to a third party. As I said at the outset of this video, ordinarily he would have had to prove that he suffered a recognised psychiatric injury, and then he would need to get a letter from the Inuries Board permitting him to bring a psychiatric or a psychological injury related claim. However, the Supreme Court has said that he may bring a case for damages without Personal Injuries Assessment Board approval, and this is a new development in the law in this area. The court's ruling clarifies that claims for damages for emotional disturbances which fall short of a recognised psychiatric disorder are not personal injury claims as defined by the Personal Injuries Assessment Board Act 2003. Nevertheless, they can be pursued through the courts, and up to now we would have advised, I think, that you can't bring such a claim because you haven't suffered a recognised psychiatric injury. Before his appeal to the Supreme Court, Patrick Dillon's case seeking damages against Irish Life Assurance plc arising from a data breach was dismissed by the Circuit Court and the High Court. The breach complained of occurred when Irish Life erroneously shared letters containing Mr. Dillon's personal and financial data with a third party. The Circuit Court and the High Court ruled that Mr. Dillon's case sought damages for personal injury, and in circumstances where Mr. Dillon did not obtain PIAB authorisation before bringing the proceedings, the case should be dismissed as being frivolous, vexatious or bound to fail. So here's a case where both the Circuit Court and the High Court said that he couldn't bring his case because he simply didn't have the authorisation from the Injuries Board. And that would have been the position up to the Supreme Court making this decision. Under the Personal Injuries Assessment Board Act 2003, a party proposing to bring a case seeking damages for personal injury must obtain authorisation from PIAB. That's a simple, straightforward letter from PIAB, but nevertheless, you must obtain it in order to pursue your case through the courts. Mr. Dillon's appeal to the Supreme Court was rooted in the question of whether a claim for damages for distress, upset and anxiety falls under the definition of personal injury in the Personal Injuries Assessment Board Act 2003, and the Supreme Court now has decided that such a claim does not fall under the definition of a personal injury. The Act defines personal injury as including any disease and any impairment of a person's physical or mental condition. In a judgment on Thursday, Mr. Justice Brian Murray, on behalf of a 5-judge Supreme Court panel, ruled that claims for damages for, quote, emotional disturbances like distress, upset, anxiety and inconvenience which fall short of a recognised psychiatric disorder like Mr. Dillon's is not a personal injury claim as defined by the Act. As such, the judge found that the Circuit Court and the High Court were wrong to dismiss Mr. Dillon's case on the basis that he had not obtained Inuries Board authorisation. The judge noted that Mr. Dillon's case is for non-material damage under the Data Protection Act 2018. This Act allows for judicial remedy, including compensation for infringement of a data subject's rights. Mr. Justice Murray noted that those who bring claims solely for mental distress, anxiety and upset, which do not require PIAB authorisation, quote, cannot expect anything other than very, very modest awards. So if you're out there and you're thinking that this is, the Klondike again, or some sort of, you've struck pay dirt with bringing such a claim, the judge is warning here, Mr. Justice Murray, that a person bringing such a claim for mental distress, anxiety and upset, which does not require PIAB authorisation, cannot expect anything other than very, very modest awards. The judge said it would be possible for a plaintiff to bring a case alleging a breach of their rights under the Data Protection Act 2018 that gives rise to a medically recognised psychiatric injury. In those circumstances, then, PIAB authorisation would be required to bring the case. So that's an interesting case. Hope you find it useful. If you do, hit the thumbs up button down below and subscribe to my YouTube channel. Thanks a lot.